discuss the scope of the freedom of speech and expression. Does it include freedom of press also? It is an absolute right. Ans. Freedom of speech and expression is a bulwark of a democratic form of government. Article 19, 1a guarantees to all citizens the right to freedom of speech and expression. According to Article 19, 2, the state may make a law imposing reasonable restrictions on the exercise of that right in the interests of the security of state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, incitement to an offense, or sovereignty and integrity of India. Any limitation on the exercise of the fundamental right under Article 19, 1a, not falling within the four corners of Article 19, 2, cannot be valid. Meaning and scope. Freedom of speech and expression means the right to express one's own convictions and opinions freely by words of mouth, writing, printing, pictures, or any other mode. It thus includes the expression of one's ideas through any communicable medium or visible representation, such as gesture, signs, and the like. The expression connotes also publication, and thus the freedom of the press is included in this category. Free propagation of ideas is the necessary objective, and this may be done on the platform or through the press. The freedom of propagation of ideas is secured by freedom of circulation. Liberty of circulation is essential to that freedom as the liberty of publication. Indeed, without circulation the publication would be of little value. The freedom of speech and expression includes liberty to propagate not one's views only. It also includes the right to propagate or publish the views of other people, otherwise this freedom would not include the freedom of the press. Freedom of expression has four broad special purposes to serve. 1. It helps an individual to attain self-fulfillment. 2. It assists in the discovery of truth. 3. It strengthens the capacity of an individual in participating in decision-making, and 4. It provides a mechanism by which it would be possible to establish a reasonable balance between stability and social change. All members of society should be able to form their own beliefs and communicate them freely to others. In Union of India v. Association for Democracy Reforms, AIR 2002 SC 2112, the Supreme Court has held that the voters have fundamental right to know about antecedents of candidates contesting election. Democracy cannot survive without free and fair election, without free and fairly informed voters. Votes cast by uninformed voters in favor of a candidate would be meaningless. In the instant case, the petitioners for democratic reforms filed a public interest litigation and for direction to implement the recommendations made by the Law Commission in its 170th report. Freedom of press. The Constitution does not contain any specific provision ensuring freedom of the press, which has therefore to depend on Article 19, 1a. In Ramesh Thapar v. State of Madras, AIR 1950 SC 124, the Supreme Court held that the freedom of speech and expression includes freedom of propagation of ideas, which freedom is ensured by the freedom of circulation of a publication, for without circulation, the publication would be of little value. The Supreme Court therefore held in this case that a ban authorizing the government to impose a ban upon entry and circulation of a journal in a state is restrictive of freedom of speech and expression, and it can be valid only if it falls within Article 19, 2. Explaining the concept of freedom of press, the Supreme Court stated in Express Newspaper v. Union of India, AIR 1958 SC 578 that no law could be enacted having the effect of imposing a pre-censorship, curtailing the circulation, restricting the choice of employment or unemployment in the editorial force, preventing newspapers from being stated or undermining its independency by driving the press to seek government aid to survive. In this case, Supreme Court was called upon to adjudge the validity of the Working Journalist Act, 1955, enacted by Parliament to regulate certain conditions of service of persons employed in newspaper establishment, i.e. the payment of gratuity, hours of work, leave, fixation of wages, etc. The ground of challenge before the court was that it would adversely affect the financial position of the marginally situated newspaper, which might be forced to go out of circulation, and thus the tendency of the Act was to curtail circulation and thereby to narrow the scope of dissemination of information. The court held the Act valid as it did not take away the right of freedom of speech and expression enjoyed by the petitioners under Article 19(1)(a). In Prabhu Dutt v. Union of India, AIR 1982 SC 6, the Supreme Court has held that the right to know news and information regarding administration of the governments is included in the freedom of press. But this right is not absolute, and restrictions can be imposed on it in the interest of society and the individual from which the press obtains the information. They can obtain information from an individual when he voluntarily agrees to give such information. In the instant case, the court directed the superintendent of the Tihar jail to permit the chief reporter of the Hindustan Times newspaper to interview Ranga and Billa, the two death sentence convicts, under Article 19(1)(a), as they were willing to be interviewed. The jail authorities had refused the permission to the newspaper representative to interview the convicts. Imposition of pre-censorship on press pre-censorship is unconstitutional. The Supreme Court in Brij Bhushan v. State of Delhi, AIR 1950 SC 129, held that the imposition of censorship on a journal previous to its publication would amount to an infringement of Article 19(1)(a). In Bennett Coleman and Co. v. Union of India, AIR 1973 SC 106, the court held that the newsprint policy is not reasonable restriction within the ambit of Article 19(2). The newsprint policy abridges petitioners' rights of freedom of speech and expression. In Express Newspapers, PVT, Limited v. Union of India, AIR 1986 SC 872, it has been held that the notices of re-entry upon forfeiture of lease and the threatened demolition of the Express building are intended to silence the voice of Indian Express and therefore violative of Article 19(1)(a) of the Constitution. In K. Abbas v. Union of India, AIR 1971 SC 481, it has been held that the pre-censorship of films is justified under Article 19(2) on the ground films have to be treated differently from other forms of art and expression because of its instant effect on persons who watch it, particularly on adolescents. Grounds of restrictions. The following are the grounds of restrictions on the freedom of speech and expression as has been mentioned in Article 19(2) of the Constitution. A. Security of the state. B. Friendly relations with foreign states. C. Public order. D. Decency or morality. E. Contempt of court. F. Defamation. G. Incitement to an offense. H. Integrity and sovereignty of India. A. Security of the state. In the interest of the security of state, reasonable restriction under Article 19(2) can be imposed on the freedom of speech and expression of a citizen. In State of Bihar v. Shashibala Devi, AIR 1952 SC 329, the Supreme Court has held that the term security of state means only to serious and aggravated forms of public disorder like rebellion or waging war against Indian government. B. Friendly relations with foreign states. The object behind this provision is to prohibit unrestrained malicious propaganda against a foreign-friendly country, which may jeopardize the maintenance of good relations between India and that state. In India, the Foreign Relations Act, 12 of 1932, provides punishment for libel by Indian citizens against foreign dignitaries. But the interest of friendly relations with foreign states would not justify the suppression of fair comment of foreign government. C. Public order. Public order means and includes absence of direct intention to lead disorder as well as the absence of tendency to lead disorder. A law punishing these disorderly acts is valid as it restricts the right relating to free speech in the interest of public order. In Kishori Mohan v. State of West Bengal, AIR 1972 SC 1749, the Supreme Court has held that every infraction of laws must necessarily affect order but not necessarily public order, and an act may affect public order but not necessarily security of state. D. Decency or morality. Sections 292 to 294 of IPC provide instances of restrictions of freedom of speech and expression in the interest of decency and morality. But it does not lay down any test for determining the obscenity. In Ranjit Udeshi v. State of Maharashtra, AIR 1965 SC 881, the Supreme Court followed the test laid down in English case of A. V. Hicklin LR 3QB 360 and held that the novel Lady Chatterley's Lover was an obscene book, as it had tendency to corrupt the mind of those who read it. E. Contempt of court. Articles 125 and 215 of the Constitution authorize the Supreme Court and the High Court respectively to punish for their contempt. In C.K. Daftari v. O.P. Gupta, AIR 1971 SC 1132, the Supreme Court ruled that a law relating to contempt imposes reasonable restrictions on the right guaranteed by Article 19(1)(a). F. Incitement to an offense. The right to freedom of speech and expression does not give permission to citizens to incite a person to commit an offense. The freedom will be curtailed on this ground and incitement to an offense is made punishable by law. G. Defamation. Sections 499 and 500 of IPC define defamation, which means exposing a man to hatred, contempt, or ridicule. These sections are constitutional as they impose reasonable restrictions on the freedom of speech and expression. H. Integrity and sovereignty of India. The right to freedom of speech and expression can be restricted so as not to permit anyone to challenge the integrity and sovereignty of India or to preach secession of any part of India from the Indian Union. Accordingly, Section 124- of IPC, which punishes the crime of waging war against the state, has been upheld as constitutional under this clause.